Let's discuss the acceptable causes for evicting a tenant in New Jersey. The first is failure to pay rent due and owing. This is the only way and the only ground in New Jersey that a landlord doesn't have to notify the tenant before filing an eviction suit. We've written a pretty detailed post on this, which you can find on our blog. It's under the Info for Landlords section, and the blog's address is www.answersforowners.com. Go on over there and check it out. Next, you can evict disorderly tenants. And tenants that are disorderly, have the ability to, you have to notice them at least once, and they can't just be evicted for on the grounds that they were in violation. Basically, what you have to do is you have to notice them, and if they still act in the same manner after the violation, then you can move to evict them. In order for you to prove your case, you're probably going to have to bring in another tenant to court to testify against the disorderly tenant, and even at that point, it may be difficult to show that the action was any more than just a mere annoyance and not really disorderly. Destruction, damage, or injury to the property. This statute does not require the landlord to give the notice a second chance. The landlord only needs to serve the tenant with a notice to quit at least 3 days before they file an eviction action against the tenant. It's important to note that the eviction for damage to the property requires that there actually be damage done to the property. You can't claim that if you have washing machines are there and it's coin operated and the tenant went in and stole money from the laundry machines, that's not considered damage to the premises. Actual physical damage must occur. Another way is substantial violation of the rules and regulations. As long as you as a landlord, you have rules and regulations for your property, and as long as they're reasonable and have been accepted by the tenant in writing or made part of the signed lease agreement between you and that tenant at the very beginning of the lease term, you as a landlord can move to have the tenant evicted. Another way is a violation in the covenants of a lease. If after a written notice to cease is properly served on a tenant for violating a covenant in their lease, which is reasonable, the landlord can file suit to evict the tenant. The tenant has to be given a second chance, and the landlord must properly serve that tenant a notice to cease, a notice to quit, and then demand for possession. It's a pretty lengthy process, and even after all of those notifications are served on the tenant, the landlord still has to wait another month before filing an eviction lawsuit. It's important to note that the covenant that has been claimed to be violated must be contained in the lease from its inception. You can't just add something later on after the fact and try and use that as a way to evict your tenant. You can evict a tenant for failure to pay rent after a reasonable increase has been made in the rent due. As landlords, you understand that you're always trying to maximize your profits, and under New Jersey law, it's the landlord's responsibility to prove that any rent increases that you make is both reasonable and not unconscionable. Be sure to be fair with your tenants when raising the rent, but at the same time, make sure that you're not unfair to yourself. You can evict a tenant for code violations. There are certain situations that arise when it becomes economically unfeasible to repair housing due to code violations, or it's unfeasible to make the necessary repairs when a tenant's still residing in the property. Other times, landlords, they're cited by municipalities for exceeding the local occupancy code when their tenants allow multiple relatives, friends to live in the property with them. When you file a suit to evict tenants under these circumstances, be sure to speak to an attorney about the appropriate additional notice requirements that you need to put in your notices, as well as the language that has to be included that discusses either relocation assistance and other programs that are available to the tenant and might be required of the landlord or the municipality to pay that relocation. If you as a landlord seek to remove your building from the rental market, you can evict a tenant, but I advise you to think really long and hard about deciding to retire your property. Be sure that you don't use this as a reason for filing an eviction suit unless you're really prepared to follow through, because the penalties for non-compliance or the landlord's failure to fully comply with the procedures laid out by the Department of Community Affairs and other governmental organizations in the state for removing that building from the market are severe, to say the least. If you want to remove your property from the rental market but hold on to it, definitely use an attorney. If you are interested in just selling and not dealing with the tenants, give us a call. We buy houses like this all the time. You can also evict a tenant if the tenant refuses to accept any changes that you've made in a lease term. So at the end of a lease, you make changes to it. You can remove that tenant at the termination of the lease when the tenant notifies you that they don't accept the changes that have been made. The changes made by you have to be reasonable, and then in order to be accepted by the court, and should the tenant sign a new lease but then violate the new condition of the lease, it's advisable that you immediately begin the process of removing the tenant to avoid a situation where the tenant can claim that you as a landlord waived that new condition since you didn't immediately enforce it. You can evict a tenant for habitual late payments. After you you give them a notice to cease, and they continue to fail to pay their rent on time. You can move to have them evicted. There is a 5-day grace period from the day that rent is due for senior citizens who may be receiving senior Social Security or retirement pensions or government pensions, which may affect the ability for them to pay on time. The courts have ruled that habitual late payments are when a tenant makes at least 2 late payments after the notice to cease has been served upon them. So keep that in mind also. You can evict a tenant if you're doing a condo conversion. This is something that's really popular in the state of New Jersey right now. It's a pretty complicated area, and I suggest that any landlord contemplating this approach contact a real estate attorney that's experienced in advising on such matter. You need to notify your tenants of your plan to convert the property. You have to give them a copy of the conversion plan, and you also have to let the tenant know that in the notice of your intention to convert, of their right to purchase their unit, and they have an exclusive right to purchase that unit for 90 days. So be careful of that. If you want to occupy your property, or you want to sell it to someone and they want to occupy the property, you can evict your tenants. There's a lot of procedural grounds. Again, this is something that you're going to want to talk to an attorney about. You can evict a tenant if it's called occupancy has been a consideration of employment. You can remove your tenant if the landlord has conditioned the tenancy on their employment as either the superintendent of the building, the janitor of the building, somebody, a handyman around the building. New Jersey has long held that in a case of an employee who received free legal quarters in addition to his salary, it was a master-servant relationship, not a landlord-tenant relationship. It's important to note that eligibility under this section requires that the employment and the tenancy be created simultaneously. While New Jersey is very pro-tenant state, they do allow landlords to use both federal and state laws to evict a tenant under certain circumstances for drugs, terroristic threats, civil violations, theft. It's important to note that under these cases you can evict your tenants if they've pled guilty or been convicted of certain crimes. You can also evict tenants that harbor individuals that have been guilty of certain crimes, as long as they're not a juvenile. So hopefully, as a landlord, you have perfect tenants and you never experience a situation where you feel the need to evict someone from your property. However, if you're still watching this, I guess you're not so lucky. I hope that you found this information helpful in resolving your tenant problems. Each of the situations that we've talked about today have their own requirements, procedures that have to be followed in order for a landlord to evict a tenant. And like I said before, we created a really helpful chart. If you're interested in getting a copy, send an email to landlord@answersforowners.com. We'll be happy to send that out to you. And also check out the Answer for Owners blog, which it's got a ton of resources for landlords and property owners, and it's www.answersforowners.com. Thanks for watching today. This is our first video podcast, and hopefully we will get better and more polished as we go on. If there's a topic you'd like to see discussed in a future video, you can email me at rich@answersforowners.com. Thanks a lot.